are bar heard.
Just one, Mr. Toomey, can I just say that I've been given, I'm not quite sure where it came from because it's not in the bundles, a copy of a statement filed by your client dated the 14th of June 2021. So we have that as well. I don't know whether you have that or have seen it, perhaps.
I don't
No.
really have it to hand.
Does anybody else have a copy they could provide? I've only just been given it. It's in response to the application for disclosure and sets out the mother's, so it's probably similar to what was said to be the other one, a sort of position statement, setting out the mother's case as to why disclosure should not be made or not be given.
Well, I'm grateful. Perhaps then I can look at that in the course of the meeting, and if anything...
This might be the only copy. Shall I? Excuse me. Unless nobody else has a copy? No.
Well, I'm very grateful.
No, sorry. Yes, Mr. Payne. Sorry to. We tried to say we wouldn't ask you too many questions, but can you just take us back a bit in time? When was the Secretary of State joined as a party?
We haven't. I don't think we have been joined.
You haven't been joined.
We're intervening.
Okay. When did the Secretary of State intervene, and for what purpose?
My understanding is that
Sorry, I've just seen Mrs. Justice Roberts joined the Secretary of State as an intervener on the 21st of May, and it was for the purposes of dealing with the disclosure of the asylum papers.
My Lord, I think that's correct. I mean, I was instructed very shortly before the hearing.
Yes. Because one of the questions that sort of comes to mind is what your why you're here. Sorry to ask it in rather a blunt way, but in other words, because you were joined to deal with the disclosure issue, and what we're concerned with in this appeal is whether or not there should be the form of any rehearing. One issue in respect of which, if that is the way the appeal went, would be the issue of disclosure. But we obviously ourselves are not going to deal with the issue of disclosure in the event that we decide the matter needs to be reconsidered by a judge at first instance.
My Lord, yes. So, from the Secretary's perspective, the issue of disclosure and the approach that ought to be taken to a set-aside application are intrinsically linked. Because if the approach to set-aside application is that a rehearing isn't required, then that we would say is determinative of the disclosure application.
Yes. So what's the Secretary of State's interest in the set-aside appeal, or the set-aside issue?
I was going to, my Lord, what I was going to do actually in the outset of my submissions was to really identify the differences between the procedures and then highlight the different considerations which were sort of relevant from the Hague Convention point of view and from the Secretary of State's point of view.
Right, okay.
Yes. I mean, I was going to do that from the outset. So,
okay.
So if that doesn't answer your questions, my Lord, perhaps we could deal with it
right.
then.
Thank you.
So, my Lord, the way I was going to deal with my submissions is just to make some general points and then go through the law relating to the immigration rules and revocation, just so there's a full understanding of that. Then deal with G, and then deal with some of the cases that have considered disclosure and the confidentiality of asylum claims in sort of return cases, not necessarily Hague Convention cases, but return cases. So if I could just start with my general submissions. The court is once again faced with reconciling different considerations, the different considerations that underpin different conventions. One requires and is aimed at facilitating the return. The other is aimed at affording protection from return. One is procedural, based on the presumption that the substantive welfare assessment needs to be undertaken in the country of return. The other requires the substantive assessment of welfare risk to be undertaken in the UK. One is private law and involves the parents. One is effectively public law and involves the asylum seeker with the exclusion of others. One is adversarial, one is said to be investigative. And the reason I say said to be investigative is I will draw your attention, my lords, to a few factors or aspects of the asylum process which might be considered to be adversarial. And indeed there are.
Haven't we had these submissions already from Mr. Hayman?
Well, my lord.
The difference between the two. I made a careful note yesterday afternoon.
Well, my lord, I'm not developing the submissions. I'm just pointing out the differences. Well, my lord, a big one. If it proves to be unhelpful, please say so, and I will move on. I was just trying to sort of provide a context against which.
Mr. Payne, just run through them briefly.
Yep.
Please.
Yeah, and then there is one is all about speed, one is about anxious scrutiny, and the difficult question that arises is that in the context of a procedural or convention that is primarily procedural, what is the impact where a substantive decision has been taken by the state in which the child finds themselves? And how should that decision be dealt with in the context of a primarily procedural convention? And in this context, should the procedural process provide for a hearing to consider the basis of the substantive assessment made in the context of the Asylum Convention?
It can't do that. The cases say they can't do that, and the two are different. What the Hague Convention could do is decide whether or not the substantive reasons for not making a return order are met. And if they are met, that's the end of that. If they're not met, then they'd have to consider return. And they may, when they want to decide whether or not to make an order for return, consider whether it could be implemented at this particular stage because of another decision. But the Hague Convention is never going to act as a review of the Secretary of State's decision as to whether or not there was a well-founded fear of persecution on a convention reason which the Ukrainian authorities would not provide protection from.
Well, absolutely, and I agree that the Hague Convention process shouldn't do that. But the question is whether having a hearing for the purposes of reviewing the asylum material and making findings in relation to that material.
Now, it's to review the question as to whether or not the criteria in the Hague Convention are met, and in doing so, whether or not the allegations that have been made in the asylum claim demonstrate that those conditions have been met or not met.
But my lord,
amongst other things, including the objections of the child.
But my lord, if that is the function, simply to review whether the criteria in the Article 13b are met, then that of itself serves no purpose, because the Hague Convention order cannot be enforced unless the asylum decision is revoked. So, in reality, there are two ways of looking at this. One is that the hearing is being undertaken simply as an exercise to consider whether the Article 13b criteria are met, in the knowledge that any finding can't be enforced, or the hearing is being undertaken in the context of, or with a view to any findings made in the context of considering Article 13b to be used as a basis or a platform to invite the Secretary of State to revoke.
Well, would you be happy with that? I mean, the whole thing, GG, was set up. If the allegations had been made and put before the court, you'd have had the decisions on that, just as you heard the decisions of Mrs. Justice Theis and Mr. Peel. And I thought the whole point was you try and march in harmony, but that requires each party to be complete and accurate in the information it provides to the court. So if that wasn't done, why are you objecting to it being done now?
Well, because, my lord, the objection from the Secretary's perspective, or the issues which the Secretary of State is concerned about, is one, finality of the asylum process. So the grant of asylum from the Secretary's perspective should bring to an end the asylum process. Two, I'm afraid we're back on to the issue of confidentiality, because for the Hague Convention hearing to serve any real purpose, the court would need to consider the asylum material as opposed to simply reviewing the material.
But if it contains allegations, you should have told the court about that at the earlier hearing.
But, my lord, you know, you with respect, this was a point you raised yesterday, and as you may recall from the many sort of refugee cases that you've considered, there are often very good reasons why information or a claim for asylum isn't made as soon as a person arrives in the UK.
How can you be making that submission in this case? It's nothing to do with the Secretary of State. You're here, I completely understand you're here to deal with the question of the confidentiality in the documents. But criticisms that we may or may not have about the conduct of the parties is as you yourself said, is a private law matter. It's nothing to do with the Secretary of State.
My lord, I'm not making submissions in relation to the facts of this case. I'm making submissions in relation to my understanding was it was a general point made by my lord as to the fact that, well, if a party, not this party, if a party delays, as I'm going to show you, if I'm allowed to, the immigration rules provide for that very consideration, i.e. a delay in making a claim for asylum, and the inferences that should be drawn from that delay.
What's that got to do with this case?
Well,
I mean, my lord is very aware of those authorities. He probably decided many of them. That that's got nothing to do with this case. You made the point about the finality of the asylum process. I understand that. You made a point about confidentiality. I understand that. And those are legitimate matters for the Secretary of State. But for the life of me, I can't see how the Secretary of State should be pitching in to what is, as I see it, a very unfortunate family dispute in relation to the Hague Convention.
well, my lord, the reason the Secretary pitched in was in response to a question or an issue raised by my lord.
Anyway, first point, finality. Second point, confidentiality. Are those going to be the two main areas of your submissions?
Well, and the third point, my lord, is the concern as to whether the use of the Hague Convention proceedings for the purpose of obtaining findings that could form the basis of an application, well, of an invitation to the Secretary of State to revoke the asylum claim amounts to a collateral challenge, really, to the asylum decision.
Yeah. Yeah.
So, as my lord said, it's finality, confidentiality, and collateral challenge.
My lord, yes. My lord, can I also say, and I'm sorry, I hadn't really focused on this issue, but Secretary is here to assist the court. So, insofar as the submissions that are being made sort of simply irritate the court and aren't there to assist, I mean, as my lord quite correctly said, the Secretary isn't a party to these proceedings. The Secretary has no interest as to the outcome of these proceedings, and so I don't want to on behalf of the Secretary of State, make submissions that the court feels is inappropriate in the context of this litigation.
I mean, I can understand the Secretary of State doesn't want the asylum process to be undermined or impeded or anything of that sort. But given that the Secretary of State was involved in G&G, I think it would be. It's in particular your last point, collateral challenge, which I'm not sure I fully understand, because in G&G it was recognised that even if during the course of the progress of the Hague Convention proceedings asylum was granted, it would still be appropriate for the Hague Court to go on to make a decision which would then be provided to the Secretary of State for the purposes of the Secretary of State considering whether that material required any. Nobody's saying the Secretary of State. The Secretary of State just has to perform her public law functions and duties. But it's my reading of G&G is that it was essentially accepted on behalf of the Secretary of State that, as I say, if an asylum decision was made during the course of a convention proceeding, but prior to a final determination, that did not prevent the Hague Court from going on to make a final determination of the Hague case, because the judgment might assist the Secretary of State.
Well,
now, is that still that was the position in the Supreme Court? So I think it'd be rather difficult for the Secretary of State to say, "Sorry, I've changed my mind."
My Lord, the position of the Secretary of State in both the Court of Appeal and the Supreme Court was that the Secretary of State accepted, and I was going to take you to the paragraphs in both judgments, the Secretary of State accepted that in principle the Hague Court could consider making a Hague order, or an order in a return order in the Hague proceedings, even where asylum had been granted.
Right.
But the Secretary did.
Wait a minute. So you'll just take us to those paragraphs. So that's the first stage. You're going to say, but the Secretary of State
didn't accept, though, my Lord, that the Hague proceedings should proceed with a view to obtaining findings that could be used, or with a view of them being used to challenge or to invite the Secretary of State to revoke an order that had been made. Because
what is happening is that the Hague Court is performing its function. Its function is to determine properly and fairly a Hague application. That's what this case is about. What is required for there to be a proper and fair determination of a Hague application? It's not about forcing the Secretary of State to do anything, or not about requiring the Secretary of State to do anything. It's simply the Hague Court performing its duties under the Convention and as a matter of civil law fairness in the process. So you don't have to go on to say, but it's the Secretary of State accepted in principle the Hague Court could consider making a return order even where asylum had been granted. And the second feature that comes from G&G, in my recollection, is the Secretary of State accepted that there could be a case for the disclosure of the asylum papers, redacted or otherwise, into the Hague proceedings.
Yes.
Because that material might be relevant to the proper determination of the Hague application. And I would assume, because again, this went all the way to the Supreme Court, that that remains the Secretary of State's position. Right. That's comforting.
Well, Lord, can I just reassure the Court that the Secretary isn't going to sort of resile on anything that was said?
Excellent. And the other thing I wanted to say is that it's because one can see it again. I know it was said in G&G. The Court is extremely grateful to the Secretary of State for setting up whatever it's called, the specific whatever it is. I can't remember how it's described, so that when there are asylum and Hague Convention, when there's asylum claim and Hague Convention proceedings in respect of the same family, same children or child, that those proceedings, the asylum claim, is dealt with by this special branch, it's wrong terminology, special group.
Yep.
And again, I would want to reiterate the court's gratitude to the Home Office and the Secretary of State for that. So this essentially, this case is a process issue. What is required, so I'm probably repeating myself, what is required for a fair determination? Has there been a fair determination in the way that it was dealt with by Mr. Justice Roberts? And I would have thought that was not a matter for the Secretary of State, speaking respectfully. Unless you want to say finality, confidentiality, but that's in relation to whether or not there is disclosure, and collateral challenge. And accepting points A and B that the court can go on and consider, I'm not sure how it amounts to a collateral challenge, which is why I want to go straight to G and G in response to that submission of yours.
My lord, yes. Well, if we could perhaps go to G and G then.
Please, thank you.
So, B. Can I invite you to go to B3?
Can I also say, sorry, just while it's in my mind, findings. I can't remember who it was who submitted. The Hague Court, the decision rarely includes findings. There has to be a finding that there was a wrongful removal or retention. Clearly there has to be that. If consent is raised, there has to be a finding as to whether or not the left behind parent did or didn't consent to the removal or retention. But in grave risk, the only issue the court is deciding is whether there is a grave risk of harm or the child being placed in an intolerable situation. There aren't findings underpinning that.
Well, my lord,
So that's,
I mean, one of the matters I was going to deal with, I'm going to have to sort of, I think, reformulate a lot of what I was going to say, given the indications as to the appropriateness of the nature of the intervention by the Secretary of State. But one of the points that I was going to make was that my understanding of the nature of the Hague hearing is not only is it that it's summary, but that it proceeds effectively on a three-stage basis. One, which is to initially take the allegations at their highest, not go into the merits of the allegations. Two, look at whether any risk can be dealt with by way of undertakings or sort of safeguarding measures. And only if those two, only if the answers to those two issues don't deal with the problem, then my understanding is that the Hague Court would then be left with having to try and resolve disputed allegations.
but that never happens.
But
I mean, I know it's an option, but because it's not the witnesses are often not here, so that's not really a. I think that would be a sort of slightly exaggerated concern to raise from the Secretary of State's perspective. But if there were findings, there would be findings.
But then, my lord, from the Secretary's perspective, it's just difficult to see the utility of the hearing, certainly in the context of a potential revocation, because if there are no findings that are going to be made, and if it is simply a question of taking the allegations at their highest, or looking at whether there are safeguarding or undertakings that can be obtained, those are really matters that or issues or steps that only risk enhancing the claim for asylum or increasing the risk for asylum, because
well, that may well be right. That may well be right. That's not the issue we have to address. As my lord said, it's just a question of, was what happened in front of Mrs. Justice Roberts a fair disposal of the Hague Convention case?
and from the
It may well be right that properly, if the matter was more thoroughly investigated that it would enhance.
And my lord, why would that not be then a relevant consideration to take into account in considering whether
Each
the
case
approach...
is different, and each case turns on its own facts.
And we don't know. You're speculating on the outcome and saying because the outcome might lead nowhere, bring the shutters down. That's quite a extreme, if you don't mind me saying so, proposition.
My lord-
Because it might lead nowhere.
Well, my lord, I didn't mean to make, but it wasn't intended to be an extreme submission. It was intended just to identify a consideration that when considering...
Yes, sorry, but it is speculation, isn't it? Because we don't know. What are the chances of the court deciding not to make a return order? It's difficult to forecast, and it'd be wrong to speculate, wouldn't it? I mean, if you could say this case is absolutely hopeless because of X, Y, and Z, then maybe. But nobody's making a submission that this case is absolutely hopeless. People are making the submission that it's come to an end. Time to bring the proceedings to an end. They've gone on for long enough. Not that the underlying merits are completely hopeless, because we don't know.
My lord,
Shall we go to G&G?
can I just say one thing? I mean,
Yes.
I had sort of structured my submissions not by reference to the facts of this case. I wasn't going to deal with the facts of this case at all.
Okay.
So
Thank you.
really the points that I was trying to raise were, and I, by the sound of it, that they aren't actually going to help the court, were really wider considerations that might be taken into account in considering or providing any guidance to the general approach to be taken in these circumstances. So just like in G&G, and in the confidentiality cases, the Secretary of State identified matters that might militate in favour of confidentiality, and then there were obviously the matters that militated in favour of disclosure. And really that was the involvement of the Secretary of State in that case. And that's really what I'm
Right.
seeking to do here.
Okay.
I'm not trying to...
No. So shall we just? You were going to take us to passages in G&G, and I would quite
I was
helped if we did that.
Yes, I was going to ask you to turn to B 360 in the bundle. 360.
60. Thank you. Yes.
And my lord, it was just to draw your attention to, my lord, if I'm not mistaken, you were involved.
I was.
Yes, so I'm going to actually just hurry through.
No, but don't worry. It was last August. Memories fade. Yes.
Paragraph 122, my lord. Just sort of
122.
122. Just reiterating something that is, I think, accepted by all parties, but in terms of, and indeed the court, in terms of the separation of functions.
Yes.
But I was just going to draw your attention to the bottom of that paragraph, which refers to the different approach in terms of female genital mutilation cases. And you may recall that this case went to the Court of Appeal, and again, the Secretary of State's concern in that case was that in an asylum claim, effectively based on the same facts as were relied on then in the sort of, if I can call it FGM
Yes.
Proceedings, that the latter was really being used as a collateral challenge to the asylum case, and that really what the court should do was take the asylum assessment and findings as a starting point, and in terms of the decision making in terms of the FGM protection order issue, and the Court of Appeal said no, that's entirely wrong. It's for the family court effectively to make the assessment in relation to the FGM order. So,
Yes.
so I was raising that as a point, in fact, which sort of went against the stance
Yes.
that I was taking,
Yes.
but just as an example.
Thank you.
But the other point I was going to make in relation to that was that a difference between the issues in that case and in this case, arguably, would be that the FGM order can be, or could be, enforced, whereas in this case, the Hague Convention order can't be enforced. So the asylum claim that didn't preclude the enforcement of the FGM order, whereas that's the distinction. Otherwise, that is a case that serves to reinforce
the different functions.
Yeah, and
Yes.
the fact that one doesn't effectively
Yes.
preclude the other.
Yes.
If I can then ask you to turn to the to paragraph 142, page B365. And this, my lord, is the point that you were asking me about, and you were hoping that Secretary wasn't going to go back on. But what I just wanted to make clear in relation to that paragraph, my lord, and you will see that the reasoning, if you look at 142,
Yes.
is Mr. Payne accepted the High Court could determine an application. And then you, halfway down the paragraph, Lord Justice Higginbotham says, the duty of non-refoulement and the Article 7 duty to allow asylum applicants to remain involves a prohibition on returning a person to his or her country of nationality. They do not prohibit either the return of the child to an effective another country or the taking of decisions which are preliminary and ancillary to return. Now that was the context in which the Secretary of State accepted that it was proper to, or that it was open to the High Court to determine an application.
So if there has been a decision on asylum, so it can't be enforced, are you now saying that in reality there is nothing the Hague Convention case can do because it's always going to be more than interim or preparatory action for removal? I mean, what's the relevance of it? Are you telling us that it's only those things that they can do, interim and preparatory action, and this case isn't one of those, or what?
No, what I'm saying is that the and it is not the Secretary's case that just for clarity, it is not the Secretary's case that the asylum decision in some way by operational law brings to an end the High Court, the family proceedings. The Family Court has obviously absolute discretion as to how the Family Court runs the Hague Court proceedings, and in the context of determining a Hague Convention application, it is open to the Family Court to consider and make an assessment in terms of applications that are made before, for example, in Article 13.
Yes.
But the Secretary of State was not endorsing an approach or the comment which we will come to of the court that where there has been a grant of asylum, there is often a real point in proceeding with a reconsideration or a further hearing or a hearing on the Hague Convention case.
It sounds to me as if you're saying, I think, and putting it bluntly, the court, even if it has power to rehear the application or reconsider the application to the Hague Convention, it should not do so ever once the asylum decision has been taken.
I'm not saying that.
You're not saying
No,
that?
I'm not.
Because I've just learned the Home Secretary is not endorsing the submission that where there was a grant of asylum, there may be a point in the Hague Convention case continue. You're not saying that?
No, I didn't. No.
Oh, right, okay.
What I said, and it is important from my perspective, just because my name is then referred to as accepting things on behalf of the
exactly. That's why I want to check.
But absolutely, and so I said, what I said was not endorsing the proposition that there is often, and I was going to go to the sentence just to make absolutely clear, a real point. We're not saying there might never be a real point, but we're not. Okay. But we're just saying that the Secretary is just saying that often, because the Secretary of State's position on this is that, and I have to confess that I had understood Mrs. Justice Roberts' reference to there being no new evidence differently from the way this court's understood it, because there might be, when we look at the revocation grounds, the clearest cut revocation ground, certainly in my experience, is, for example, a nationality. Now, someone isn't of the nationality they've claimed. So let's say there was evidence, I don't know, a passport or something that the person in question wasn't a national, which hadn't been considered. And one might say the appropriate way of dealing with that would be just to submit that evidence to the Secretary of State. You wouldn't need a rehearing or hearing, but you could just submit that evidence to the Secretary of State. But in those cases, that might be a consideration. The court might say, well, actually, look, there's this evidence just been obtained. We'll have a rehearing. So the Secretary is not saying that it's a bar, but it's just that the Secretary of State is keen to try and ensure that the comments that have been made primarily in GBD, primarily in terms of the two processes operating in parallel, don't end up with the view being taken that unless the Hague Convention Court has considered all the material that the Secretary of State had before it, there should effectively be another hearing.
There may be exceptional cases. The starting point may be if everything's been done, what's the point? There may be other cases where in reality there's not much more. But if there is a case where there's a real suspicion that material was not put to the court, which should have been put to the court, or could have been put to the court, and the court says, well, hold on a moment, the other parent has a right to a fair hearing of the Hague application case, and that will look at it. The Secretary of State wouldn't be troubled by that. No. Indeed, the Secretary of State might find it useful if it emerges, for example, that everything that one parent said was a pack of lies and what the other parent was saying was true. The Secretary of State may want to look at that, you just don't know. But all of that is so far down the line. But there could be exceptional circumstances, and possibly where there's new material, that would be an example of an exceptional circumstance.
Absolutely, my Lord.
Yeah.
So, Mr. Payne, I've made the note that the Secretary of State does not want the fact that G&G emphasises the processes to be operating in parallel, then to be used by people to say that unless the Hague Convention Court has taken into account all of the material that the Secretary of State took into account, there should be another Hague Court hearing.
To consider any additional information. Absolutely.
Yeah. The difficulty with all that, of course, is that nobody knows what the material is and therefore what the differences are.
My Lord.
And so we can't make any decision, as I said yesterday, based on that. We simply know there are differences.
My Lord,
It shouldn't be a case of whichever door you open, the Secretary of State is in first.
Might I say it in this way? I am aware, I remember your reference to Kafka, so I'm trying to tread lightly on this point, but it isn't really that the Secretary of State submissions, they are made with a view to the Secretary of State being through the door first. The Secretary of State's position is that it is almost inevitable that there will be different evidence in an asylum claim to the evidence that's in the Hague Convention claim, if only because it's very unlikely, well, I don't know, but whereas it's almost inevitable in an asylum case that country information, there'll be evidence as to country information and cultural, that might be more...
Yeah, that's the key problem here. I could understand if it was said that native speakers of one language, or people whose language is one, were getting rough treatment and the authorities would never take place. That would be one situation. But all the hints that we get from Mrs. Justice Roberts is that this was based on allegations to do with the conduct of one person towards other people, with the implication that that was on a convention reason, that he was behaving badly because he didn't like the ethnicity of the mother of his child, and that the Ukrainians wouldn't bother to do anything about it. You're trying to piece together, and we just don't know. But obviously, if it's a country thing, you can't send somebody back to country A because they're gay or something, then that would work. But it doesn't seem to be the basis of what's happened here. But we don't know.
No, and I'm trying to avoid addressing this case in particular because I mean that the court indicated displeasure on that in relation to that point.
Well, and the point is, there's not a right to the disclosure of all the material into the Hague proceedings. So it may well be that there is material available to the Secretary of State that will not be available to the Hague Court. So I don't think that should be a real concern, that the absence of all the material might lead to other hearings until all the material is received, because that's not the reality of it.
But in terms of the points that you made, my lord, yesterday, was that in fact, to be honest, the court's made is that it is the fact that Mrs. Justice Roberts has referred to the fact that there is additional material, that suggests that, or is a factor that supports there being, in terms of fairness, a hearing. I mean, that's certainly the way I understood the indications from the court. And the Secretary of State's position is that merely because there is additional evidence considered by the Secretary of State shouldn't per se be a factor that points towards or towards the need for a further hearing, because that would apply to nearly every case. And indeed, my lord, in terms of G versus G and the judgment in G versus G, one of the factors which I was going to take you to, in fact, we might as well go, can we go there now, please? And that's at B366.
Yes.
So I'm going to just take them slightly out of order. So subparagraph 4.
Yes.
And you reference there to the available evidence, although overlapping will almost certainly be different.
Yes.
And so that is a point, my lord, which the Court of Appeal said, well, that's a reason why the proceedings should proceed in parallel, or the process should proceed in parallel, with a view to making the available evidence, or any available, the evidence available in one process into another. And
well, then examples are given there, aren't they? Country guidance and anonymous whistleblower.
Absolutely. And on the other hand, in the middle, whilst the evaluation of the evidence in the convention application has to be made within the confines of the summary process, the evidence adduced and submissions that one will almost certainly play no part in any asylum claim. So from the Secretary's perspective, though, the question that arises is whether, having had that benefit in terms of the determination process of the input and in terms of the Hague Convention material and any judgment, so having had that benefit, in other words, that's informed the Secretary of State's decision.
Yes.
The issue then as to whether having effectively the two processes having worked together, there should then be a further hearing for the Hague Court effectively to carry out a further fact-finding hearing.
But that, I think, is the problem, you see. You're assuming that the situation worked as in G. Everything was before the one court. It made its decision. Decisions went to the Secretary of State and she took her decision on the basis of everything. And then simply to go back in that situation and say, well, that's the perception of the Secretary of State on the evidence. And the claimant says, no, I want to have the court express a different perception. What we have here is different against a context of repeated failures to comply with the order, and without any explanation as to why suddenly there was a change on the 19th of October, generating an asylum application on the 20th of October. We have a judgment which says there was inconsistent information and it appears to be connected with the actions of the father, but we're not sure, rather than anything to do with changes in circumstances in the Ukraine. And the question then is, you haven't had the two processes going in parallel, and it's not the Hague Convention case marking the Secretary of State's homework. It's an individual who's a right to have a Hague Convention case determined. He's got his order, one party refused to comply with it, she's got another, or the child has got a decision from the Secretary of State, and the father says, I would like, if that's going to be set aside, for there to be a Hague Convention decision on the material that I haven't seen yet, but which perhaps he should have seen first time round. That's the difference, you see. That's why this doesn't fit neatly into your review and collateral challenge, because something seems to have happened which the father hasn't looked at and which you don't have the views of the Hague Convention Court on.
Well, in terms of a general submission, not addressing the facts of this case, in terms of the two processes operating in parallel, one process, the Hague Convention process, is intended to be completed within 6 weeks. As you know, the asylum process takes quite a lot longer, even if expedited. So, in terms of the processes operating in parallel, you're almost inevitably going to have the Hague Court reaching a decision before the asylum decision is made. And you're almost inevitably going to have the asylum decision being based on different evidence, not least because, as the Supreme Court accepted, in asylum claims, people are interviewed, so you're going to get the information they give during interview, which won't be available to the Hague Convention Court.
It depends. I mean, if you're interviewing the mother here, she presumably would have said the same things to the court as she would have said to the Secretary of State. You can't assume she's going to tell different stories to different people depending on what she thinks is best for the outcome. She must surely be telling the Secretary of State what she told the court.
Well, again, just not by reference to this case, but I mean, my Lord, you know, as you're well aware in terms of asylum claims, the asylum claims are largely determined on credibility, because, you know, on the face of the allegation, if they're accepted, it's not true, but they're often, if you just accept the allegations, they're often going to be.
It follows, if the chap is telling the truth that he's been tortured in wherever, then it follows that you're likely to grant him asylum. Yeah, I mean, leaving aside sufficiency of protection, internal flight, but basically, so in this case, the Secretary of State had the Hague material, had what was recorded in terms of the accounts provided, had whatever was said, whatever information was provided in the asylum case, and has where there's a presumption under the immigration rules that unless someone has a good explanation for delaying, making a claim for asylum, it counts against them, and is in a position to compare discrepancies, any discrepancies. So that asylum decision has been taken, if properly taken, will have been taken on that basis. And so, although it's said that the Hague Court won't be marking the work of the Secretary of State, on another view, if, as is accepted by was accepted by the father in this case, if the primary purpose of the hearing is to obtain evidence or findings by the court, if the court makes findings to be used as a revocation, then that could be seen from one perspective as effectively undertaking a review of the process. I mean, that's what he might like, but the court might say to him, that's not what the Hague Convention case can do.
I like that, but it was one of the
possibilities envisaged in G&G and expressly endorsed. Paragraph 155, little 5, first two sentences.
Is this the one, in addition, the Secretary may interview a child?
No, paragraph 155, little 5. The Secretary of State is under an obligation to determine an asylum application. Where that status has been granted...
Sorry, my Lord, are you reading from the Supreme Court or the Court of Appeal?
The Court of Appeal. We were in the Court of Appeal judgment.
My Lord, yes, a big one, yes.
1555, page B370. Where that status has been...
I'm sorry, my Lord, I was on 144, sorry.
Do you have 155?
Yeah, big one. Yep.
Where that status has been granted, but the court has determined that a return order should be made, Secretary Mr. Payne, in our view, rightly acknowledged that she would be under an obligation to reconsider refugee status. So that envisages asylum's been granted, the Hague Convention Court says there should be a return order, and so it's accepted that the Secretary of State would be under an obligation to reconsider refugee status.
Well, Moylan, this was a paragraph I was going to deal with because what the Secretary accepted was that, in principle, if there were...
No, you've been asked, you're not resigning.
No, I'm not resigning, my lord, but this is a shorthand for what the Secretary of State accepted earlier on, because, and to be honest, my lord, it's unlikely to have been precisely what I said, because the immigration rule cited there is incorrect, and I have referred to the Secretary's position on this issue for 4 years, starting back to from F versus M, and the Secretary's consistent position is, and has been, that if there is evidence that warrants reconsideration of a revocation... Sorry.
We're talking about evidence, we're talking about the decision of a Hague Convention Court.
But merely, my lord, making an order, for example, without any Article 13b consideration. Yeah, let's just say the court makes an order. I'm
asking you now, do you accept the second sentence of paragraph 1555? And that's a yes or no question.
No.
I didn't think you did. Because if it's right, that's an answer to this case. Because Mr. Toomey very fairly does not draw a distinction between a hearing and a rehearing.
No, well, I'm not drawing a distinction between a hearing and a rehearing.
So if 155 little 5 is right...
No, my lord...
That's it?
No, my lord, I am saying...
But you say it's not right.
Well, my lord, with respect, you're trying to push me into saying something...
Well, I just want to know whether something
to...
that's in a decision of the Court of Appeal and therefore binding on us is right or not.
My lord, I have...
In your submission.
I'm saying that the mere making of an order doesn't oblige the Secretary of State to reconsider refugee, well, it's not reconsider, to consider revoking refugee status.
No, it depends.
I mean, how can just an order?
Well, I don't think that's not how I read paragraph 5. It's saying, of course, it's saying it depends. There's not an absolute rule. But the general principle you accept is that if that the making by the Hague Court of considered judgment, or delivery of a considered judgment, and an order for return may create an obligation on the Secretary of State to reconsider.
Absolutely, and even if there isn't an order, even if there isn't an order for return, sorry, even if there is an order for return, but there are findings or there is evidence in the judgment effectively upholding the 13b.
Yes.
Yeah, but they say, for example, he's not actually from the nationality he says he is.
Yes.
That would require a reconsideration. But it's not the simple
But again, we're speculating about what might happen.
No.
And you're trying to elevate it into a matter of principle. And what we're doing, I'm afraid to say, is looking at it, and I appreciate the Secretary of State's concerns, we're looking at it from the point of view of this case.
Absolutely.
And I think that's where there's a slight mismatch, is that you're turning it into a sort of a general concerns, because you acknowledge, and it's accepted, that the court can consider making a return order, even when asylum has been granted, and also that it can be appropriate for the asylum papers to be disclosed. And if the asylum claim had been made at the same time as the Hague application in this case, there would have been an application for disclosure of the asylum papers. And that might have been successful. And then we wouldn't be in this position. Because I think you're concerned that the family division might come back and say, well, we think there might be more or something else. So that's what we're dealing with. That what was anticipated in G&G hasn't happened. They haven't been made in tandem or parallel or at the same time or similar times. So we haven't had the opportunity to consider a disclosure application. When I say we, the family court hasn't had the opportunity to consider a disclosure application, hasn't had the opportunity to consider the material then disclosed, all the material, including any responses from the father. So it hasn't considered those matters in the context of the Hague application. That's where we are. Does that help or not help?
It does not, and I'm not going to press my luck any further.
Well, I don't want to.
Well, my lord, I mean,
I don't want to stop you expressing the Secretary of State's concerns to say, please don't do this or please don't say that, because we can see difficulties further down the line if you say this or do that. That's. I absolutely don't want to stop you from making those submissions.
Without that, my lord, then might I make two? First of all, might I just be absolutely clear that Secretary isn't resiling from what is said in subparagraph 5, yeah? Because that's been suggested on a number of occasions. The simple point that's made is that, and that's why I took you to the previous paragraph, as to what the Secretary of State accepted. And the reason why, and when you look at the Scottish case, that paragraph appears to have been taken to mean that whenever there's a return order, yeah, then the Secretary is under a duty and has accepted that it will consider under an obligation to consider whether to revoke refugee status. That was not the Secretary's position and is not the Secretary's position. It is only if there is evidence that suggests that the criteria aren't met.
Can we bring it down to sort of rather a mundane example? A judgment and order, return order, is made by the Hague Court subsequent to the grant of asylum. That is then sent to the Secretary of State. It's going to be read.
Yes.
It's not going to be put in a drawer and
Absolutely.
ignored. It's going to be read.
Absolutely.
And so the Secretary of State is going to decide whether, in the light of what is said in the judgment and anything else, whether or not she should be reconsidering refugee status.
Yeah, but absolutely, Moylan.
And I think that's what 5's saying. It's an obligation. It's an obligation to look at the material and see what obligation it creates on her, or how she's properly then to exercise her duties.
My lord, yes, and to use an equally mundane example the other way, if in fact an order is made and a judgment is made which makes no findings or is unable to make any findings in relation to anything relevant to an asylum claim, but the Secretary of State then wouldn't, just by virtue of the order and the judgment, have to then consider that judgment, especially if it wasn't sent to the Secretary of State. So it's not.
If it's not sent, but if it is sent, that's what I'm saying. The Secretary of State isn't going to put it straight away into a drawer.
No.
The Secretary of State is going to read. Somebody's going to read it and decide what do we have to do. What obligations does this create for us in response to receipt of this judgment? Absolutely,
Moylan. I'm being pedantic then, but it's just a reference to the fact of a return order triggering the obligation.
Under an obligation to reconsider.
Yeah, absolutely. So in terms of a judgment being sent, yeah, which needs to, with information sort of relevant to revocation, then the Secretary is under a duty to consider that. Absolutely.
I think really your case can be summarised in 3 sentences. In principle, it's possible for there to be a further consideration of the Hague application, but the Hague Convention Court should be astute to remember its own limited role. It's not checking on the Secretary of State. It should be astute to make sure that the other parent doesn't try to misuse the Hague Convention. If an order is made and the Secretary of State becomes aware of it, she will have to consider what, if any, step she needs to take in the light of the order being made. If it's simply an order saying return, that might be the end of it. If it puts her on notice that the asylum system might have been misused and she might have been encouraged to grant refugee status when it shouldn't have been granted, she'll be hopping mad and we'll get onto it straight away.
Absolutely. The criteria of revocation, absolutely.
And that's the Secretary of State's position, I think.
Yes.
Yeah.
Yeah. And then, the second point I wanted to raise, my lord, was that
Let me just make a note of what I've just said your submission is.
they were quite a long 3 lines, but
Can we consider Hague Convention needs to be aware of its limits, needs to be aware not to allow misuse of the Hague Convention process. Secretary of State, if becomes aware of any order or judgment, will have to consider what, if any, steps he needs to take in response to it.
yeah.
And you say about the Scottish case that elevated the duty to, or the potential looking at it and see what, if any, steps, because it may not need any steps to be taken by the Secretary of State, that elevates it to a duty to reconsider.
My lord, yes.
And that's your objection to that case.
Yeah, if I'm permitted to do that is my...
Yeah. No, I understand.
And my lord, perhaps I'm just staying on the Scottish case. The other point is really that, if you remember, that the focus of the Scottish case is on welfare findings. Yep. And what the Scottish court says is that there are likely to be welfare findings, and those are likely to be taken into account in terms of revocation of asylum. Yeah, and that is, I'm afraid, incorrect. I can take you to the guidance, the API, Secretary's API on the issue.
So you say there's a mismatch?
Sorry, say it again. I was looking at the Scottish case.
Should you want to go to it?
No, I want you to repeat what you said.
All right.
I didn't take
Well, the thrust of the rationale in the Scottish case is to, because they ask the same question, what is the use of the hearing? And they say the use of the hearing is that it's going to be a welfare hearing, they're going to be welfare findings. And the welfare findings, the court's view on the best interest of the child, are very likely to affect the Secretary of State's view on refugee.
I can't.
And that's just wrong.
Because you ask, is it a well-founded fear of persecution on a convention reason?
Absolutely.
Where the state cannot protect or will not protect, and that's it.
Yes.
And best interest is actually almost irrelevant.
Well, I mean, the API. Well, I'm afraid
it is irrelevant.
It is irrelevant. I mean, if you want, I can show you the API. But it's irrelevant to the question of status. Yeah. It's relevant to the question of what to do if the status is revoked. Yeah, because it's a two-stage process. You've got leave, and so your revocation status doesn't mean that you lose your leave automatically. I mean, it's pretty likely, but then Section 55 and best interest kicks in on the leave point.
Yes, exactly. Yeah.
Can I just, if the court was making a welfare decision about where a child should live, and it was being submitted that the child or the parent, either the parent was going to go back, would be subject to some form of persecution, that is an issue that the court would have to address in making its welfare determination. And if the court decided that it was not only unfounded but false, and that was a significant factor in its welfare determination, then that, as the Secretary of State submitted in paragraph 54, quoted in paragraph 13, accepted the Secretary of State as a public law obligation to consider material relevant to the discharge of her obligations to revoke the grant of asylum. So it's not the best. It's not. Sorry, it's page 10. Sorry, it's B294. It's internal paragraph 54 of the submissions, which is paragraph 13 of the. It's the Advocate General's.
Yes,
the Advocate General's
it's
submission.
paragraphs taken from FSM.
Sorry, it's paragraph taken from F first. So that's what. So it's not the best interest in itself. It's what underpins the court's determination as to what is in the child's welfare, because one can see the two being linked.
Absolutely, my lord. I mean, absolutely. But I get a sense sometimes that I'm just being too pedantic on these things. But what I'm trying to say is that, and it's set out in F versus M, those paragraphs 54 to 57, which are the submissions that I made.
Yes.
And so this is the Secretary's position, which hasn't changed. It's absolutely that if there is evidence that arises in the proceedings, that brings into question or might justify revocation, absolutely. But what if you look at the focus of what actually the court found is, if you look at B298, the question they ask is.
Sorry, hold on. Yes.
So B298, paragraph 23 at the top. The competent issue is stark one. It turns on whether the making the order would have any practical effect. Yeah. So.
Well, what they say there, it would be a matter which the Secretary of State would be likely to have regard to. Yes.
But my lord, yes. But if you look at the middle paragraph.
Well, can we just go through it a bit?
Yeah, well, I was going to go through it a bit. So if you just go through the middle bit of paragraph 24.
Oh, sorry. Okay.
It says just above that bottom hole punch. The focus of and the process in the present proceedings would be different. The inquiry would concentrate on M's best interests. Then there were these references to Scottish acts.
Yes.
And then it would not be able to pronounce the order unless it considers in the best interest, in other words, for the parents. A standard proof civil standard.
Yes.
Then it says 25. The court says, although an order for the return and delivery pronounced by the court could not be implemented, it would be a matter for the Secretary of State would have regard to. Now that's the point I was making earlier. And that the simple fact of an order,
yes,
doesn't trigger. My lord, and if I could just carry on.
Well, wait a minute. I don't think that's what's, because this is assuming a detailed judgment setting out the court's conclusions of what is in the child's best interest.
Absolutely.
And what the court is saying is that is a matter which the Secretary of State would be likely to have regard to. And I can put a tick against that, can't I?
Yes.
Yes. Okay.
No, but my lord, if you I've totally accepted that. I entirely accept that a judgment which refers to matters relevant to the revocation of asylum, the Secretary of State will take into account.
Yes.
But the point I'm trying to make here is that the order per se, no. In terms of looking at the judgment, what they say is going to, the judgment's going to focus on. If you carry on, it says equally. So they looked at just the order. Now they say equally, so they're going on to the judgment. Equally, if the court made findings which tended to indicate it would be M's best interest to be in her parents' care, they would Secretary would have likely regard to those findings. Yeah, but simple best interest findings as to where it's better for a child to be, or with whom, wouldn't be something that would be taken into account in terms of taking revocations.
The findings which tended to indicate. I mean, if the findings were to be good for this child to be close to its siblings and its father, that wouldn't tell you anything about the convention.
No, that's what I'm saying.
But if it said this child would be better off with its siblings and there's no risk to him,
absolutely,
then it would be.
Absolutely.
But I mean, they do say which tended to indicate. I think you're over-reading it actually, which tended to indicate that it would be. The Secretary would be likely to have regard to those findings. It's not an absolute. Once the label best interest of the child is to be with the father, end of story, or close to the siblings, end of story, or in the country where he grew up, end of story. But if there are things there which on the way to finding out the court's decision what's in the best interests are material to whether or not the Secretary of State wrongly or erroneously granted an asylum refugee status, then the Secretary of State will have regard to it. I mean, say the mother, in a case, put in a witness statement in the Hague Convention saying, I made those allegations, I was under extreme pressure at the time, I shouldn't have made them, they're not true, I'm sorry I made them. Then that, of course, might be something the Secretary of State might want to look at.
Absolutely. So, well, my lord, what I'd focused on was the focus in this case on simply just best interest assessment.
Yeah.
And what the court said is the order or findings would be matters which would likely to lead her to consider reviewing the grant of asylum. And the simple point I'm making, and I won't take any more time on it, is that a simple best interest assessment won't. Best interest assessment that reviews material relevant to revocation won't.
Yeah.
So the focus shouldn't, with respect, or the Secretary's position is, the focus shouldn't be on best interest. It should be on, in terms of like when you're considering what the potential
The reasons
impact.
why it's in the best interest.
That's right. So simply saying an assessment of a welfare assessment would be likely to lead to a review. Secretary submitted is incorrect. Well, can I just wait one point, because I'm not going to, I don't want to trouble the court further, but in fact, can I make two further points? One is that there's been a lot of reference in Re G to the Supreme Court's decision, and the paragraph in Re G where there is a reference to the court having the power to reconsider.
Yes.
Yeah, and that's the only reference that I can see to revocation in the Supreme Court judgments. And it's paragraph 158, page B450. And the simple point that I wanted to make really was that what paragraph 158 actually says is, if as a result of the decision, it doesn't say the grant of asylum, it doesn't limit it to that, because there are in fact multiple decisions that Secretary can take in terms of on an application for international protection. And there is a case that's currently going through the court where the Secretary has refused asylum, but allowed the appeal on Article 8 grounds. And so there, the Hague Court is considering whether to set aside the application in the context of that finding and additional evidence. Now, the approach that's been taken in that case is by the High Court judge was to say, and it might be relevant in terms of the issues that you were raising with my learned friends in terms of the approach in these cases, was in that case, the abducting parent was effectively given a time frame within which to make an application to set aside. So it wasn't allowed just to float around, because he was saying, well, let's just wait. And then within that application to set aside, the abducting parent sought to rely on the asylum material in support of the set-aside application, but sought to resist disclosure. And the High Court said, no, if you're going to rely on that material, you need to disclose it.
Yes.
But if you don't want to rely on it, you don't need to disclose it. And then the set-aside hearing has taken place on the basis, without the asylum material, whilst an appeal to the upper tribunal is outstanding. And in the
An appeal against the refusal of
the
asylum.
First tier tribunal, so the Secretary refused the whole application. It was appealed by the asylum seeker.
Right.
The first tier tribunal rejected the asylum appeal,
Yes.
but allowed the human rights.
Okay.
The Secretary of State appealed the human rights aspect
Yes.
of the decision,
Yes.
and the asylum seeker
I see.
appealed the refugee aspect.
Right. And that's still outstanding.
Yep. But the process that was adopted in there was not to wait for, in accordance with G, not to wait for the outcome of the asylum process, but to look at disclosure along the way.
Yes.
And
Yes.
effectively make that
Yes.
finding. But look at the set aside, to look at the set aside issue without the asylum material.
Yeah.
And-
Because it wasn't being relied on by the taking parent.
Absolutely.
Yeah.
Absolutely. But the point I was just trying to make in terms of 158 is that there are, in fact, quite a wide variety of decisions the Secretary of State can take, some of which might justify reconsidering or considering setting aside, some which may not. But I don't. I think it'd be wrong just to focus on 158 as saying or as referring to a grant of asylum as being the focus of that paragraph.
It could include a grant of asylum.
Absolutely.
Obviously.
Absolutely.
You're saying it does not necessarily mean a grant of asylum.
It's not limited to.
No. Well, I was actually going to make quite a few more submissions, but
Can you were going to say something about the immigration rules to show what so that we don't misunderstand what the general powers are. We referred to some yesterday. But were there any others that you?
Yes.
Do you just want to tell us?
Could I just? This shouldn't take long, Milo. Could I just take you through the relevant ones?
Yes, please.
So, Milo, if you can start at A44, and there you have paragraph 334, the criteria which need to be satisfied
Yes.
done.
Yes.
336 is said a refusal of asylum, and the point just you may wish to note is that reasons for refusal, there's a requirement on the immigration rules for the Secretary of State to provide reasons for refusal.
Yes.
There is no concomitant obligation where there's a grant.
Yes.
338A sets out the person's grant of refugee status, the revocation, mandatory terms. That reflects, which I will take you to, Article 34, 33 and 34 of the Procedures Directive.
Sorry, Mr. Payne, just on that previous point, the refusal of asylum at 336, it requires reasons, but there's no similar provision the other way.
No, that's right.
For reasons for granting it.
Yeah.
So that's a potentially relevant factor here if the grant of asylum is, as is said, the complete answer. It would be a complete answer that for which there is no obligation to give reasons.
Yeah, my lord, yes, and as
So English, Emery, and all of those cases, none of those apply. So you could lose, as it were, without having any reasons.
Well,
I mean, the grant is for them, in this case, as we know, the mother.
I see, my lord.
There's no reason.
So-
There's no obligation to give reasons for that decision.
Well, the grant is to the child, and there's no obligation to give reasons. There's no prohibition on giving reasons, and the question may well be: does a biological parent of a child have a right to know why his child is a refugee? There may be judicial review arguments, if it ever came to that, as to whether or not on those facts reasons should be given. So you can't say there's no obligation. There isn't an obligation.
Under the
there isn't a
rules.
prohibition, and then the question would be whether the common law would fill any gap.
My lord, yes, and sorry if I didn't make that clear. I was just trying to. All I was trying to say was there is an obligation under the rules to provide reasons for refusal, but not a grant.
Yeah.
And that reflects, certainly in terms of the rules, that reflects the fact that you can't challenge a grant.
You can certainly understand why the father of a child would have no right to know why a mother of the child, with whom he's not in a continuing relationship, was granted refugee status. May be different, as I say, if it's your own child.
As you say, my lord, I mean that might be a sort of public law JR issue in terms of that.
And I just don't know whether the father here has written to the Secretary of State asking the Secretary of State exceptionally to grant reasons as to why his child has been given refugee status. I just don't know whether that's happened or whether he's even thought about it. So it's probably a red herring.
Well, it may turn out not to be.
Right. So 338A.
Yep. 338A.
Maybe revoked or renewed.
And my lord, just one point, because if you remember, one of the an example was given in terms of 339A 5 and 6, change in circumstances, and an example was given in terms of the Ukrainian court's decisions. If you remember, the January decision, the May decision, and the Supreme Court. And the Secretary of State would consider any change by reference to the paragraph at the bottom. Can you see under 6 there's in considering 5 and 6? You need a significant non-temporary
Yes,
change. So,
thank you.
and then you've got 339AB, you've got the misrepresentations, and you can see at the top of page A47 that the misrepresentations need to be decisive to the grant of refugee status.
If they thought the child was under the active jurisdiction of a foreign court and there was no reason to believe that the foreign court was not taking its duties seriously, would that be a material change? Or could it be a material change? Because it might be, might it?
Well, my lord, I mean, as you said, in terms of sufficiency of protections premised on the judicial system or the authorities not providing adequate protection. But so an individual court making an individual orders, it'd be quite difficult to see how that would undermine the view taken of the totality of the system. I mean,
yes, exactly. It depends on why the Secretary of State thought that the system wasn't capable of granting protection, and whether or not the reason why she thought that, it might be a factor indicating. Yeah. But it can be no more than that. Yeah. So it's capable, it depends on the circumstances again. Yeah.
Well, it's pretty up. And then you've got 339B, which just distinguishes between status and
sorry,
leave.
339B,
that's A47.
Yeah. Oh, right, yes.
And then 339BA sets out the process, in other words. Yep. And then I just wanted to take you to 339L, which is at A53. And you'll see that really sets out the obligation on the asylum seeker to establish a claim.
Yes.
If you look over leaf at A54, you'll see subparagraph 4, which refers to if a delay. Yep. Early as possible, unless they can demonstrate a good reason.
Yeah.
And then, if we could then just go back to the Procedures Directive at A34. And although you should see at A34, you should see Articles 37 and 38. And although it's referred to as withdrawal of refugee status, it's revocation. It's the same. Yeah.
The same.
And then A38, my lord, is it's the procedural rules. And if you look at A38 1D.
Sorry, wait a minute.
So you're
A38.
Sorry, A34, beg your pardon. Article 38.
Oh, right.
Sorry, big one.
Yes, sorry. 38 1 B
D.
D. D. Yes. Yes.
And then I was going to, if it assists, I was just going to very quickly take you through the asylum policy instructions, the relevant pages, just so you can understand the process a caseworker would follow. C427.
Wait a minute. C.
C, my lord.
Let's go to the other bundle.
Which page?
C427. Starts at C424, but the opening paragraph is at C427.
Yes.
And you've just got the purpose of the instructions set out. C428, under paragraph 1.3, you've got the policy intention.
Yes.
Just one point to raise, again, in terms of the change of circumstances, my lord. In terms of the first bullet point, the change of circumstances is really the focus of considering that is when the 5 years leave comes to an end. Yep.
Sorry, where are we?
So 1.3, and then there's the first bullet point.
The first bullet.
Yep. and that's referring to
see.
changing
Yes.
circumstances. So it's not
Yeah.
a continuing review during the 5 years leave. It's effectively at the end. That's when that's.
Yeah.
Then you've got paragraph 1.4, the second paragraph. A child's best interests are not a factor,
Yeah.
but they are a factor if you read the whole paragraph before the decision to remove. So that's the thing the distinction I was drawing before. 439 refers to the fact that it's normally appropriate to give the UNHCR an opportunity.
Sorry, Mr. Payne. 439.
439. Paragraph 3.6. This is the process. It's normally appropriate to give the UNHCR opportunity to present their views. From memory, they're normally given 10 days.
Yes.
Then C442 deals with the appeal rights.
Right.
And also the different issue of cancelling leave. C450 and C451, that deals with the approach to misrepresentation.
Yes.
My lord, those are the relevant pages.
Thank you. Thank you very much. No. Mr. Payne, thank you very much indeed. Yes, Mr. Harrison.
My lords, Mr. Payne, during the course of his submissions, made reference to another Hague asylum case, which is the subject of active consideration in the courts. In fact, I think all of us in this front bench either are actively involved in the case or have been involved in the case at one stage or another. It's a case in which there are some judgments in the public domain that appear on Bailey, although the more recent judgment to which Mr. Payne made reference in the course of his submissions, whilst in final approved form, hasn't been published, and as I understand it, the judge, Mr. Howe, QC, sitting as a Deputy High Court judge, has not given permission for it to be published. I think Mr. Payne has made a request to the judge for permission to use it for the purposes of these proceedings and has yet to hear back. But I think none of us, or certainly neither Mr. Payne nor I, would, for our part, object to your lordship seeing the judgment, subject, of course, to the judge giving permission.
But it's dealing with a slightly different issue. It was referred to by Mr. Payne just to point out that it's not binary. It's not refusal grant of asylum. There might be other decisions made by the Secretary of State which might or might not be relevant to the issue of whether or not the Hague application is reconsidered. So it didn't sound as though it was going to have anything directly relevant. That's
no,
what I'm saying.
It is a case, I mean, in common with this case, it is a case in which the claim for asylum was made after the conclusion of the Hague process. So the Hague return order had been made, and the respondent to the Hague proceedings, after attempting to seek permission to appeal from the Court of Appeal, which was refused, then in the sort of window between that refusal and the date on which implementation of the return order was due, caused a claim for asylum to be made on behalf of the child.
Right.
Now, the child in that case was refused asylum by the Secretary of State after a number of months, and the issue at a case management stage was that the father was in the process of appealing, and it was apparent that the various stages of the different tiers of appeal were likely to themselves be ongoing for a number of months, and what his preferred course of action was to take no further steps within the Hague process until all possible avenues of appeal within the asylum process had been exhausted. But he made it clear that once he had exhausted all possible avenues of challenge within the asylum context, it was his intention at that stage to make a set-aside application, which would then have led to a further process of
So
delay
the
in
father was
process.
the taking parent.
The father was the taking parent. and the
A
mother was
return order had been made.
yes.
Child makes an asylum application which is rejected. That is being appealed.
Yes.
It's not yet determined. And the father has simply said that, tell the court that he's not currently intending to make an application to set aside the...
Well, his stance...
or he will make it, but only once...
That was his stance at the case management hearing. And
I'm still not sure the case is going to help us.
well, but what I mean, the approach taken in that case, because there was an issue considered as to whether the court should deem the father in those circumstances to have already made the application, and the court did not go down the deeming route in that case. But what it did do was use its case management powers under the family procedure rules to direct the father to make the set-aside application. Right. And so that was made, and I mean, I haven't been involved at this stage, but as I understand it, that set-aside application was timetabled in conjunction with a related application to enforce an overseas order under the 96 Hague Convention to a hearing that has recently taken place for a different judge, albeit judgment hasn't been given.
Do you want to see that or not? No. It doesn't sound so. No.
But the secondary, more recent issue to which my learned friend referred was the disclosure question. Now, in that case, as we understood it, the father had relied within the asylum claim on what one might term material from a whistleblower or whistleblowers. In other words, third-party witnesses whose evidence hadn't been introduced in the Hague process and which he wished to maintain confidential. Now, essentially, a twofold decision was given by the judge to the effect that the confidential material met the Dunn test of strict necessity and therefore shouldn't be subject to a freestanding obligation of disclosure. However, the father, by the same token, should not be allowed to rely on this material within an application to set aside, because that would have been in conflict with principles of Al-Arawi and secret justice. So the decision was taken on those two bases.
Okay, thank you.
Sorry, but that's just not right. I mean, if you're interested, but I'm afraid that's just not right.
Speaking for myself, I'm not interested in a case that's not reported, that I can't refer to.
I think we should...
I know secrecy is very big in this case and in this field, but enough is enough.
I think we should leave it.
Very well.
Okay. Especially if you're not going to agree about what is said.
Well, the other relatively small points I wanted to come back on is, first of all, my learned friend's concern about paragraph 25 of the Scottish case and the potential for best interest findings to be made, triggering an obligation on the Secretary of State to look at matters again, or a likely obligation. In my submission, it's more of a hypothetical than a real concern, because a court undertaking a best interest evaluation doesn't do so in the abstract. In other words, it doesn't put aside, potential issues of persecution and risk and undertake some sort of best interest analysis as though they
hard to see how it could be in the best interest of a child to send him to a country where he's going to face persecution.
Well, it's inconceivable that a court discharging its duty could come to that conclusion.
His conclusion that the child wouldn't face persecution would not, however, be binding on the Secretary of State. It could be wrong, and it could be different evidence.
Yes.
So
thank you.
It might be a hypothetical concern. My learned friend at various points described the Hague Convention as essentially a procedural instrument. In my respectful submission, that's not quite right, because it's not just about procedure. Although there are procedural aspects to it.
I think, to be fair to Mr. Payne, that is sometimes how you might see it being described in some judgments.
Yes?
So I understand why he made the submission. But equally, I think when you read it, if you read it literally, it's rather simplistic.
I mean, I acknowledge it is sometimes said that it's really not about making substantive decisions, it's about deciding which country should be making the substantive decisions. But it is also about more than that.
Yeah.
Because, I mean, obviously one of the main objects of the Hague Convention is the prompt restoration of the abducted child to his home environment.
And a decision about any grounds on which the application is opposed.
Yes. My own friend Mr. Toomey, during the course of his submissions, suggested that it would be open to the father sort of almost immediately. I think tomorrow was the way he characterised it, just to make an application in this jurisdiction for a substantive welfare determination. In our respectful submission, it would be a little bit more complicated than that because of the existence of ongoing proceedings in Ukraine. I mean, these were proceedings initially commenced by the mother, and I think looking at the chronology of the father at some later stage, cross-applied by way of counterclaim in Ukraine for orders that the child should live with him.
That was the mother's application for leave to relocate.
But those proceedings are ongoing, and the effect, I think, of Article 13 of the 96 Hague Convention is that for so long as the matters within those proceedings remain under consideration, there is, in effect, a sort of lees pendens issue which would preclude the courts of England and Wales from conducting their own substantive welfare determination.
Yes.
And so those Ukrainian proceedings would either have to come to a conclusion or there would need to be a transfer of jurisdiction or transfer of the case pursuant to the mechanism contained within Articles 8 and 9 of the 96 Convention.
Yes.
And finally, my lords, probably been forgotten about in the midst of time, I think your lordships asked me yesterday whether the report obtained by the mother from an independent social worker raised issues relating to racism and nationalism on the part of the father. Moylan LJ and Ms. Watts has taken the opportunity to look through that report, and we can confirm that issues of that nature do not feature within it. I'm told that the focus of the report is really on the impact on the child of being returned to Ukraine and being removed from his new life in England, and in particular separation from his family, including his stepfather.
Thank you.
We developed a relationship.
Thank you.
It didn't concern an allegation of that nature.
Thank you.
But although, I mean, if it was a sister call, we don't object to the court seeing that report, although it has been formally introduced.
Thank you.
Unless there are other matters I can assist you with,
thank you very much.
some submissions in reply.
Mr. Toomey, have you finished with that statement?
I have, thank you, my lord. I've had a... Sorry.
Is there anything you want to say about it, or I mean, just that I thought you should know that it's. As I said, I don't really know where it came from, how it's in the papers.
Well, I'm grateful, I think, for it. Thank you.
You're the only person who has it.
That's for once a little power in this court. Well, there is a reference to immigration, but my instruction on that is that it's immigration more generally rather than asylum.
Right.
If that was something that
No,
was
I
triggered, but
okay. So thank you. There's
but
no.
I can pass it.
Thank you very much. We're just going to. Can you pass it up? We're going to rise for 5 minutes.
All right.
It's actually.
My lord, shall I just tell the
Could you, please? Thank you. Mr. Toomey, that statement was in the bundle filed with the application for permission to appeal. Sorry, that was it. I wanted to tell you where it was. That was all. So you could identify. So there was a bundle filed. My judicial assistant had that bundle, which we didn't have, and she found the statement in that bundle. Thank you all very much for your respective submissions. We're going to reserve our judgment. It will be handed down in the usual way, in the sense that it will be provided to you in draft, which, as you all know, but for the benefit of everybody in court, is for the purposes of correcting grammar, not content. And we would hope that once you receive the draft, you'll be able to agree the order consequential on it, and we'll try to endeavour to give you the judgment as quickly as possible, but I can't provide any indication currently as to whether that will be before or after the vacation. So thank you all very much.
Discuss things outside.